Negotiable Instruments Act, Section 27, Agency. Section 27 of the Negotiable Instruments Act, 1881 deals with the principle of agency in relation to promissory notes, bills of exchange, and cheques. This provision recognizes that commercial transactions are often carried out not only by principals personally, but also through agents acting on their behalf. It clarifies the extent to which a principal may be bound by the acts of an agent in matters relating to negotiable instruments, and also defines the limits of such authority. 1. General rule binding through a duly authorized agent. Section 27 provides that every person who is legally capable of binding himself, or of being bound, in accordance with Section 26, may bind himself or be bound through the act of a duly authorized agent acting in his name. This means that if a person is competent to contract and incur liability under a negotiable instrument, he may authorize another person to perform such acts on his behalf. When the agent acts within the scope of the authority granted, the legal consequences of the act fall upon the principal. The principal becomes liable as though he had personally made, drawn, accepted, endorsed, or delivered the instrument. Thus, the law recognizes the commercial necessity of agency and permits negotiable instruments to be executed and dealt with through representatives. 2. Requirement of due authorization. The authority granted to the agent must be lawful and valid, and the agent must act in the name of the principal and within the scope of the authority conferred. If the agent exceeds such authority, the principal will not be bound unless the act is subsequently ratified. The section emphasizes that only a duly authorized agent can bind the principal in matters relating to negotiable instruments. 3. General authority does not include power to accept or endorse. The section provides an important limitation that a general authority to transact business and to receive and discharge debts does not automatically give an agent the power to accept bills of exchange so as to bind the principal. It further clarifies that such general authority also does not empower the agent to endorse bills of exchange on behalf of the principal. This means that even if an agent is broadly authorized to manage business affairs, collect payments, or settle debts, such general authority does not, by itself, empower the agent to accept a bill of exchange on behalf of the principal or endorse a bill of exchange in a manner that creates liability for the principal. The authority to accept or endorse negotiable instruments must be expressly granted or clearly implied from the nature of the business and circumstances. 4. Authority to draw does not imply authority to endorse. Section 27 further clarifies that an authority to draw bills of exchange does not, by itself, include the authority to endorse them. Drawing a bill of exchange and endorsing a bill are legally distinct acts involving different types of liability. Therefore, even if an agent is authorized to draw bills on behalf of the principal, such authority does not automatically extend to endorsing bills, and a separate and specific authority is required for endorsement. This distinction ensures that principals are not unintentionally exposed to liabilities arising from endorsements unless such authority has been specifically granted. For more details, contact us.